Okay. Okay.
All right, Mr. Chair, you are live.
Thank you, sir. I'd like to call to order the Board of Appeals for the City of Haverty Grace. Tonight, we are conducting a hearing for a request for a modification of a non-conforming use. This meeting is done in a virtual format. For the record, we'd indicate that in attendance and present would be Mr. C. Cole Hawkins, who is the applicant, represented by Mr. Elwood Stark, his attorney. The city is represented this evening by Mr. Shane Grimm, and we have Mr. Volney Ford with us, who is the chairman of the Haverty Grace Planning Commission. Attending for the board, Charles Packer, Chair, Phil Powell, Candace Boselli, and Jeff Carhart. I would just like to inform everyone here tonight that we consider any testimony you make coming forward will be under oath, as if you had been sworn as of this evening. Does anybody have any objection to being that their testimony is considered as being under oath? Okay, if there is no objections, I would like to start just to thank everyone for being here and for participating in a virtual setting in the hopes of being a more safe procedure. The codified zoning ordinance of the mayor and city council of Haverty Grace specify procedures governing the operation of the Board of Appeals of the city. Section 3 dictates administrative requirements to be met, and prior to this hearing, which includes advertising, posting of the property, notification of applicable property owners. Mr. Grimm, have these all of these aspects been conformed with? Shane?
Sorry, I'm still getting used to unmuting myself. Yes, they have. They have all conformed with all of them.
Okay, have we had any requests for any information or any written correspondence from any interested parties?
I have not, sir.
Okay, thank you. The ordinance governing the operation of the Board of Appeals for the city of Haverty Grace is a matter of public record and is available at City Hall should anyone wish to review this. I'm not sure we have anyone watching or in participating that is, however, this hearing is available on YouTube tonight. What we have before us tonight is a request for modification. The Board of Appeals seldom hears such a thing, but it is expressly in the code, essentially a request for a variance. So we will operate under the same procedures as a request for variance, wherein we give consideration to that specific property, and we will hear testimony regarding that property. And there are only two items that we need consider. The question of whether or not literal enforcement would create an unreasonable hardship or practical difficulty. And the second would be that the granting of relief would do no substantial injury to the public health, safety, and the general welfare. So at this time, I would ask for, I guess, Mr. Ford to make a report to us as far as the Planning Commission's hearing. Volney?
Thank you, Mr. Chairman. The Planning Commission met on November 30th, 2020 to hear the above referenced case in which the applicant seeks to modify an existing non-conforming use to convert an existing two-family attached dwelling structure from its existing classification as a duplex dwelling into the new classification as a semi-detached dwelling. The purpose of this modification is to allow the overall duplex structure to be divided into two independently marketable properties along the common boundary of the two existing lots of record upon which it is currently situated. An inadvertent and unintended hardship was created when the zoning ordinance was modified after the duplex dwelling was constructed. With appropriate city approval on non-conforming lots of record that existed prior to March 15th, 1982. The zoning ordinance provides that such conversions of classification under such circumstances can be granted by the Board of Appeals. The Planning Commission found that an inadvertent and unintended hardship does exist and that no adverse impact on the streetscape or nearby residential property owners would be created by this modification. The Commission voted unanimously to recommend that the Board of Appeals grant this request for modification of a non-conforming use to include recommendations and suggested conditions set forth by the Planning Department in its staff report dated November 25th, 2020. Thank you, Mr. Chairman.
Thank you, sir. Just for the record, I believe every member of the Board of Appeals did receive a copy of the memorandum from Mr. Ford, which he just read into the record. Also, we received from Mr. Grimm a Department of Planning staff report, which did include a plot plan layout for the question property and the entire block of Erie Street involved. And Mr. Grimm, do you have anything you wish to add regarding your memorandum with your staff report?
Sure. Thank you.
Shane?
Yes. Thank you, Mr. Packard. So the project that we have before us tonight is actually very convoluted, but after discussions with Mr. Stark, we felt that it was appropriate to move forward with a case that would ask for a modification of a non-conforming use in order to submit or substitute one non-conforming use for another. As Mr. Ford indicated, this project was approved in 1998, where the Planning Commission we assume because there is no record for some reason, but we assume the Planning Commission approved it because obviously the duplex dwelling was constructed after that. Subsequent to that, the city changed the zoning code to introduce the semi-detached dwelling and duplex dwelling definitions and those uses in certain districts as permitted and conditional uses with certain required setbacks. So the duplex that Mr. Hawkins constructed could not meet the setbacks that were required in 2009 when they put that into the city code. Likewise, it could not meet the setbacks for a semi-detached dwelling as well. So with that being said, the code allows for the board to substitute one non-conforming use for another. So in this case, we are substituting a non-conforming duplex for a semi-detached dwelling that will also be non-conforming. And that can be done in accordance with section 205-3A subsection 4, which states modifications of non-conforming uses to other non-conforming uses and modification of non-conforming structures to other non-conforming structures shall be permitted with Board of Appeals approval. The department has reviewed it against all the applicable sections in the code, and we find that it has no adverse impact on the community, and in fact, no passerby or citizen would be able to tell that anything is different. Simply what will happen is Mr. Hawkins will have his surveyor prepare a preliminary subdivision plan, which will then go to record plat and be recorded in the land records. Once that occurs, then Mr. Hawkins can sell those properties individually because each unit will be on its own lot. So again, the department recommends approval of the substitution of one non-conforming use for another at 920 Erie Street subject to the first condition: the Department of Planning will administratively review and approve the subdivision. The applicant shall prepare a final plat in accordance with Chapter 173 of the City Code, and the plat must be recorded in the Hartford County Land Records. And secondly, the final plat shall include the addresses for the lots and any applicable easements. And that's all I have at this time, Mr. Packard. Thank you.
Thank you. Mr. Stark, are you going to speak for the applicant?
Yes, sir.
Or is
Yes,
Mr.
that's
Cole?
correct. And
Okay.
if you haven't noticed, Mr. Hawkins is right there up in the corner right, or at least my corner right.
Yes,
And so that's, you can, I guess you can wave maybe or something like that. There we go. Good evening to the Board of Appeals. My name is Elwood Stark. I'm a member of the law firm of Stark and Keenan in Bel Air, Maryland. We undertook this case because we thought it was a case that was meritorious, and I hope that we can help Mr. Hawkins in this matter. I assume that you all have had the opportunity to review this section of this code. It's somewhat unusual, a substitution of one use for another. And I thought it was relatively unusual. And I thought that it would be something that would be appropriate for the Board of Appeals. And after talking with Mr. Grimm, I thought that it would be something that would be good for the city and also good for Mr. Hawkins. Now, I have exhibits which I had introduced in the Planning Commission, but I'd like to address them. We have exhibits A through G, and they may come into reference, but certainly for a record, they would need to be placed in the file of the case. So I'm not sure how we're doing this.
Adam, if you could put those exhibits up, I'd appreciate it.
Okay. Can you just reference what exhibit you got first?
A would be the deed. This is the deed from Irwin and Hayden, two of my clients, dated July 16, 1998. It would be shown as Exhibit A.
Warming it up right now. Can everyone see that?
Yes, I can see it on my screen, Adam.
Okay.
I also see it.
Oh, I apologize. Hold on. I'm sorry, give me 1 second, please.
Unless we have anyone objects to entering that deed as an exhibit A. We apparently have a copy of it because it's been shown, so. Mr. Grimm, you do have copies of all these exhibits?
Yes, sir, I do.
Okay.
Would you like me to continue the deed, the various exhibits one by one, or do them collectively?
You have other exhibits that you wish to
Yes,
present? Or
yes.
go right ahead, whatever
All
whatever
right.
pace works for you, sir.
All right, thank you. Exhibit B is a photocopy of a small photocopy originally of Hopper's map, and that was how the deed had described the parcels. And it's if you can look at the box, I'm sorry, I guess we're not up yet.
Adam, can you present Exhibit B?
I'm sorry. There you go.
All right. Now, this is an exhibit of the 3 lots that we'll be talking about in this case. And you can see that it's divided into 3 lots. And if you go look back to the deed, that's how it would have been described. Exhibit C is the conditional use notice that our client got back in let's say it would have been 1998. And there was a request for a conditional use at that time. Next would be a June 16, 1998 letter to Mr. Harkins about a hearing that would be held before the Haverty Grace Planning Commission on Monday, June 22nd, 1998. And could we move forward, please? Now, this is a plat, and if you would look, that's great, thank you. Toward the intersection of Erie and Ohio, you would see the 3 lots, although one looks like 2 lots. And it's divided, the one that was the Ohio Street side is the parcels that we are talking about. There was a 3rd property bought, but it was not involved in this particular matter. All right.
Can you hear me?
Yeah.
Can you
Yes,
hear
sir.
me? Yeah, okay. I wasn't sure whether you could hear me or not. I just wanted to clarify that last picture that he showed the same 3 lots that was on the Hopper's map. The first one
Correct.
there, the 597 one, was mentioned in that deed. There was those 3 lots, 597, 598, and 599. But the one on 597 was a single family, even though that was part of the deed, and I own that one as well. But that isn't part of this issue. I just wanted to make sure I didn't want anybody to get confused that we were trying to interject some other property. It's just the one at 598 and 599. But
Thank you.
what he can continue on. I feel that Vonnie and Shane explained it just as eloquently as it could be put, really. I mean, it was, there was a decision made. I mean, I honestly can't remember. I talked about this Monday night, but I honestly can't remember, to tell you the truth, what the decision was made back in 98. But obviously, just as Mr. Ford had stated, they obviously had approved what I ultimately ended up building, because they issued permits. It was inspected. I received the use and occupancy permits, and everything was fine back then. But as Shane stated, as the years progressed, things changed. Now all those years I kept it as a rental, and so it never mattered to me. Every time I got the tax bill, it showed the one address with the 2 lots, but owning both of them, it didn't really matter. But now my situation has changed and the market has changed, and I wanted to sell them. And we had a contract to buy the property at 922 that is on the lot 599. But then when the buyer's closing agent went to research this, that's when they discovered that there wasn't a separate tax ID number. So really that's what all of this is for, is just to simply get that lot legally separate, so it can be assigned a separate tax ID number. I just wanted to clarify all that. That's really all this is about. We're not creating any new lots. We're not changing the structure. We just need to get a tax ID, a separate tax ID assigned to the unit on the 922 side. Sorry.
Let me go through, if I could, please, the last 2 exhibits. And they are both permit applications and zoning certificates from the city of Havre Grace, and they are the 2 different street letters, which was 922, as you see on the first one, and the second one will be 920. Now, I did want to address Mr. Hawkins, and what he had said earlier is absolutely correct. However, we do have to make a record in this matter, and I figured that would be an appropriate thing to do. Now, I'm going to be asking questions, and then he would be answering the question that I would be asking. I hope I do this right, and I'll try to be as brief as I can. Now, can you, excuse me, can you hear me, Mr. Hawkins?
Yeah, sure can.
All right, excellent. I'm sort of trying to back up so that we can get this in a position that it would be something that we could use if we would need to do so in the future, which we would hope that would not be the case. Sorry. He did build to the code, as you can see on those 2 zoning certificates. And what had happened to him is that, and his wife, is that there was a change in the code, as Mr. Grimm said. And passage of time also usually is something that non-conforming uses have an issue about. There were, if you look at the deed, you will see there were 3 lots. And if you look at the plat, you'll see there were 3 lots, separate lots. Now, he has made the use of the property as a rental homes, and now he would like to sell them. And that would be what the purpose of this particular hearing is about. Sorry, bear with me a minute. sort of let me finish up. I think that the request of Mr. Hawkins was done very well earlier. And if you have any questions, I'd be glad to certainly answer them rather than go through my examination on this matter. Any questions that y'all would have?
I have just a couple of questions, if I can.
Sure.
First off, the lot that you're going to split, make two properties, they presently both have an independent address, 920 and 922 Erie Street.
Yeah, well, first of all, I mean, technically, in my mind, we're not really splitting anything, as what he tried to explain.
For the purposes of sale, you're
yeah, but I mean, that, you know, we're not really divided. We're still, it's still those same three lots. That's what he was trying to say. But yeah, they had been given, they were assigned two separate addresses from the very beginning, as he pointed out on those permits.
okay.
It was 920 and 922. When we built them, they all have separate utilities, water and sewer hookups, you know, separate meters. They were all totally two separate units. It's just that on the tax ID thing, it was listed as one tax ID number.
The reason I asked the question is, you know, should the board determine to proceed with this and allow this request, there were two conditions that were expressed in the staffing report, and one of them was that it showed and included the individual lots. And I wanted to be certain that there were already two individual lots, and that the other is that the Department of Planning would review and approve the subdivision of it. So you're, I assume, aware of both of these conditions, and I just want to make sure that should we accept them, that you also are willing to abide by those two conditions.
Right. I mean, tonight's just the next step that we needed to, you know, or the next piece of the puzzle. Once I get approval tonight, then that'll be the thing I move on to tomorrow to try to get this thing finalized.
Does any other member of the board have any questions regarding this matter?
I don't have anything at this time.
Nothing said. Candy, you're good. Phil?
I'm good, Mr. Chairman.
And Mr. Carhart?
I'm good.
Jeff, are you okay there?
Yes.
Thank you. Is there anything anybody else wishes to add? Okay. If there is no other testimony or questions, we can move into a little bit more of an informal position for discussion purposes with four members of the board, and then we will come back to being on the record for our report of our positions. Can you guys unmute and we can all talk over one another. Any question on anything? I mean, I think it's a very straightforward request, and it's just one of those peculiarities about the zoning ordinances that have these things. And in their wisdom, they allowed us to be able to substitute non-conforming for non-conforming. So I have no problem in my own mind. Are we of like mind, or do we have different of opinion?
I don't see any problems, Charlie.
Jeff, you,
I'm fine.
okay. Well, then we can go back on the record and I'll ask that one of you make the motion, one of you second it, and we'll proceed.
Mr. Chairman, I will move to accept the applicant's request as outlined in the city staff report to include the 2 stipulations noted.
Do we have a motion to grant the request with the 2 stipulations as defined in the staff report from the Department of Planning? Do we have a second?
I second it. I second it.
Candace or Jeff, can we have a second?
I second it.
Okay, we have a motion. And we have a
Second
second.
it.
Thank you. We have a motion and a second. And I'm sorry, what'd you say, Phil?
Nothing. I said Candace seconded it.
Okay, all right. This is a little time delay here on the, right. Okay, I will call roll. Please vote in the affirmative or the negative. Phil, Mr. Powell,
Affirmative. Affirmative.
Mrs. Boselli,
Yes.
Mr. Carhart,
Yes.
Mr. Packard, Chair, votes yes, and that's 4 in the affirmative, none in the negative. Mr. Hawkins, we have approved your request and certainly wish you the best of luck in the endeavor. Let me further state that for the record, the proceedings of the board are a matter of public record, and they can, of course, be appealed by certain actions which are delineated in the city code. Anyone who may wish to avail themselves of the ability to appeal our decision from this evening can do so. If you contact City Hall, they can give you whatever information you may need as to how you go about making an appeal. If there is nothing further to come before us, we will adjourn with congratulations to Mr. Cole and our thanks to Mr. Stark. Thank you.
Thank you all.
And also
Appreciate
to
it.
Mr. Adam Brzezinski.
Yep.
Thank
Thank
you,
you all.
sir.